Government forcing fees to unions forcing pink slips. Now, if I could just back up a little bit here. If you've watched this show with any regularity over the years, you know I love to eat yodels. One of my stage managers going so far as to buy me an entire yodel truck for Christmas. Now, look up yodel on Wikipedia, and you're going to find my name right there. So imagine my dismay when I hear this morning that the maker of these fine bakery delights filing for bankruptcy protection. Drake's part of the empire that makes yodels, that's part of Hostess, that's part of Twinkies, that's now maybe part of history. The CEO blaming in part pricey union contracts. And forget what it means for me. This is not about me. Well, it is about me. But this is also about you, and it couldn't come at a worse time for the president. The judge here to explain.
I have some good news for you. It's what's called debtor in possession bankruptcy, meaning they are going to continue to make your yodels. There might not be as much sugar in them. You might have to wait longer to get them, but you can get them, especially
Well, what do the unions have to do with it?
Well, here's what the unions have to do with it. Drake's, the holding company, during the course of its existence, has purchased other bakeries. And those bakeries had deals with labor unions. And now those labor union members are retiring and they want to cash in on their pension. Drake's also has its own deals with its own labor unions. And those folks want to retire and cash in on their pensions. And Drake's doesn't have the money to fund the pensions. These are binding contracts. What do you do when you cannot comply with the terms of a binding contract? You go out of business and everybody loses everything? Or you go into a bankruptcy court and you say to a judge, make this fair to everyone. I want as many people to work as possible. I want as many benefits to these people as we can afford, but I can't do what I can't afford. That's what's going to happen now. Why? Because of these super rich mega deals that labor unions carved with Drake's and with these companies that Drake's bought. Bad time for this to happen.
Here's what I don't want to see happen. The union argument outstanding, them putting half the cream in the Twinkies or the yodels. Do you think that's a possibility?
I do not think that's a possibility. I think you can sleep well tonight.
I don't buy it. I don't buy it. You know nothing
You think
about
I'm just trying to be a nice guy?
You know nothing about these culinary delights. If your menu doesn't have the tassel on it, you don't look at it. All right, Judge.
Take the cannoli.
Yeah, just run.
A Mississippi judge has blocked the release of 21 inmates after Mississippi's now former governor, Haley Barbour, pardoned them and others on his way out of office in Jackson. The judge says the pardons may be in violation of Mississippi's state constitution. The now former governor granted clemency to hundreds of people, including more than a dozen convicted killers, 4 of whom went free this weekend.
We've got our law enforcement officers out watching the ones that we think are a danger that have been released.
The governor himself ought to have to look me and the family in the eye and say, hey, I'm going to let this guy go. But there wasn't any of that. That's the coward's way out, if you ask me.
We invited former Governor Barbour to appear on this newscast. He and his staff have not returned our calls, but he did put out a statement to all the media saying most of those he pardoned have already served their sentences and that his decision was based upon the recommendation of the parole board in more than 90% of the cases. Chris Gutierrez has more on this, and he's live for us. Do we have a sense now, Chris, why the judge believes this may be illegal, what the governor did?
You bet we do, Shepard. The Attorney General there in Mississippi has asked that judge that you mentioned before to take a good look at these pardons, Shepard. And the reason is the state's constitution says that any inmate that's seeking a pardon must publish notice of his or her intentions in a newspaper in the county where that inmate was convicted before they can be pardoned. Obviously, it gives people time to object. In this case, though, Governor Barbour granted so many pardons, the AG doubts that happened. Listen here.
Estimate there may be as many as 175 that we'll have to look at. And it appears from our preliminary review that a vast majority of them will probably be illegal pardons.
You know, Governor Barbour has been in office, Shepard, since 2004, and before this flurry of pardons this year, we're told that he only granted full clemency to just 5 inmates in the past 8 years, Shepard. Kind of puts it in perspective.
Yeah, it does. And now 5 men have already been released. What do we know about those 5 men?
What's interesting about them, Shepard, is the fact that 5 of them, all 5 men, they were all trustees at the governor's mansion, and 4 of those, what's troubling to some, 4 of those 5 were actually convicted murderers. Take a look. We have their pictures here. Take a look. Anthony McRae, for example, was convicted of killing his wife back in 2001. Charles Hooker, next to him, was serving life sentence for murder back in 92. David Gatlin killed his estranged wife in 93. And Joseph Osment was convicted in 94 of killing a man during a robbery. But again, what has a lot of people talking, both Democrats and Republicans, Shepard, is the fact that Governor Barbour issued so many pardons, 215.
Chris Gutierrez live for us. Chris, thank you. Let's get over to the legal panel on this. But first, our senior judicial analyst, Judge Andrew Napolitano. He anchors Freedom Watch over on the Fox Business Network. This look legal to you under the Constitution, Judge?
Well, on its face, it looks legal for a couple of reasons. Mississippi has what's called a strong governor. That is a governor who can pardon people for any crime except treason. No one's currently serving a term for treason. That would be treason against the state of Mississippi, not against the federal government. And he can effectuate those pardons without anybody's approval. Now, just a couple of basics. A pardon wipes out the conviction. It eradicates it. So the person could answer under oath, I was never convicted. Clemency, on the other hand, is think of it as mercy. A person's term in jail ends. They still have the conviction. It doesn't wipe anything out. They can just go home free. Most of these were clemency. They were not pardon. But the troublesome ones are the pardons. And the Mississippi Constitution does say that the person seeking the pardon must publish their request. It doesn't speak to a pardon that is initiated by the governor. That is, where the inmate didn't seek it, but the governor just granted it. But because this is a strong governor system, and because the Supreme Court of Mississippi has said the governor can pardon whomever he wants, I think these inmates and the governor are going to win. I think ultimately these pardons are valid. In fact, I think they were valid the moment he signed them, and it was improper for anybody to hold them up.
Including this judge who held them up.
Including this judge. Now, the judge is immune. The judge presumably didn't do it for a nefarious purpose. The judge is actually looking at the law. But under the law of pardons, as it is generally understood, once that pardon is signed, that inmate is free, the conviction is vacated, and anybody that interferes with that is themselves potentially interfering with justice.
Now, in the case of the pardons, you would now be able to vote. A convicted felon would now be able to vote because you're no longer a convicted felon.
Correct. You'd be able to own a gun. If you were a lawyer, you'd get theoretically your license to practice law back, although that's a little iffy. But all the disabilities visited upon you as a consequence of that conviction are gone. It's as if they never happened.
Is this political that we're seeing here, or are people, you know, because the governor knew some of these people.
Yes, yes.
And some of these people who were pardoned have long since been out of jail.
Because the state of Mississippi has an elected attorney general, and because the new governor is a Republican and the attorney general is a Democrat, you have not heard from the new governor, who's a friend of Governor Barbour, but you sure have heard from the attorney general, a clip from whom you just ran. It probably is political. In fairness to the attorney general, I'll say this. It's odd, the group of people that he pardoned. Murderers are rarely pardoned when the crime is one of violence and they haven't even served half of their term. It's valid, lawful, and in my view constitutional, but it is unusual and odd.
I can't wait to talk to him about why he did it and what went through the
Well, you know, he's a good friend of yours. I bet he'll be here.
You know, I don't know. He's not returning calls right now. I'm sure he's very busy.
Yes.
But we'll see. Raise Ole Miss some money, Governor. Thank you.
Thank you.
You can catch the judge on Freedom Watch, 8 o'clock Eastern Time, 7 o'clock Central.
A memo from the Justice Department finds that President Obama's recent recess appointments are, wait for it, legal. Even though critics argue Congress was not technically in recess, the ranking Republican on the Judiciary Committee, Senator Chuck Grassley, says, quote, the Justice Department opinion is unconvincing. Its conclusion is at odds with the text of the Constitution and the administration's own previous statements.
Our own Judge Andrew Napolitano, the host of Freedom Watch, joins us live to analyze this. Okay, so the Department of Justice came out to say, yeah, our boss did exactly the right thing and the legal thing in making those recess appointments.
Without demeaning my profession, you can get legal arguments to support almost any position you want. And when the president...
I've seen people try to indict ham sandwiches.
Exactly. And when the president goes to the Justice Department and says, I got to get this guy in office because the Senate won't confirm him, give me some legal authority for it, that's what they do. This is a well-written, well-reasoned, 28-page legal argument, but there are a lot of flaws in it. And lawyers for, say, Senator Mitch McConnell, the Republican leader in the Senate, could have written an argument more convincing on the other side had this been a battle of lawyers. Here's the problem. This document says that the determination of whether the Senate is in session or in recess is not made by the Senate, it's made by the President. Now, the Constitution...
That doesn't make any sense.
Not only does it not make any sense, the Constitution says the Senate shall be the judge and determiner and author of its own rules. The Senate decides when it's in session and not. Let's see. There are senators going to the floor of the Senate every 3 days. It would seem to me the Senate has decided that it's in session, and the President is not in a position to reject that.
Did the President, Judge, ask a legal counsel their opinion prior to making the decision to reassess a point?
It's a great question, Eric, and we don't know the answer.
And why don't we know that answer?
Because the document was released yesterday, and we don't know when the document was drafted. Mr. Cordry was appointed about a week and a half ago.
Right. And the thing that has stuck in the craw of a number of Republicans is Cordry was brought up by the Senate, and they simply didn't get enough votes to advance it. So essentially, he was killed off in the Senate because they didn't get enough of the supermajority. And so then when everybody's on vacation, they go, you know what, he's our guy.
This will raise your blood pressure, and I'm sure you know this. The Senate cannot touch his salary, because who pays his salary? The Federal Reserve under Dodd-Frank. Look, the flip side of this is every single president, from George Washington to Barack Obama, has from time to time waited until the Senate was on recess and then appointed someone they thought they couldn't get through the Senate. But that's the exception, not the norm. To these people in this document, it's the norm.
And didn't George Bush want to recess appoint someone but decided not to when the Senate did this exact same thing? Every third day they'd throw someone up there,
George Bush did both. George Bush both deferred to the Senate and defied the Senate with John Bolton, who was a recess appointment. Right. And guess who ripped into George Bush for doing that? Senator Obama.
Sure. What are the odds of that? So if the White House can set the hours for the Senate, can the Senate tell him what his hours are?
It'd be very interesting if they tried. Sometimes the Congress is like a potted plant that lets presidents get away with too much.
Thank you, Judge.
Just my editorial.
All right, sir, we'll be watching you tonight on the Fox Business Network.
Former Army Private Bradley Manning, a.k.a. altogether now Brad-ass 87, could face a court-martial. The military officer overseeing his case made the recommendation just yesterday. It means, basically, that he thinks there's enough evidence against the 24-year-old Brad-ass 87. The former Army specialist accused of leaking government secrets to the website WikiLeaks. Let's take this to our senior judicial analyst, Judge Andrew Napolitano. He anchors Freedom Watch over on the Fox Business Network. What's your beef here?
Well, the system is intended to provide the defendant with an opportunity to see the evidence against him and to challenge the evidence. In the civilian life, that happens before a grand jury. Defendant is not there. Defendant's lawyers are not there. The government presents their case to the grand jury. They almost always get an indictment. In the military system, instead of a grand jury of 23 people, you have a hearing officer, one person, who basically conducts a mini-trial. The decision is not, is he guilty? The decision is there enough evidence to make a case here to bring it before a jury? In this particular case, the hearing officer was himself, in his civilian life, is himself in the civilian life a federal prosecutor. He's a National Guardsman on weekend and evening, and was during this hearing, but during the day from 9 to 5, he works at the Justice Department and prosecutes people. Question, should a person like that be evaluating evidence, or do they have sort of an inclination towards the government and against the defense?
That's not a question. There's only one answer to that.
Well, they made this application to him, and he denied it. He said, I don't know anything about the case. I have nothing to do with it. I've never been involved in a military prosecution, and I'll be fair. He probably did the right thing. There's certainly enough evidence here to bring it to a trial jury called a court-martial. The issue is, what will the defense be? The defense will be that I revealed the truth and the public has the right to know the truth. That's probably not a defense that will work.
What he said.
I just wonder what you think. I'm surprised that they would have someone who's in that sort of capacity.
I think I'm the only one who disagrees here. I mean, with all due respect here, I think that prosecutor's going to sit there and say, listen, I spend my life doing justice. So you know what? I can weigh out the facts here. And, of course, I'm going to say, and again, as you said, and I don't know in the military so much, but you can indict a ham sandwich. So I don't think it's very hard to pierce through those issues to say.
True, but I don't think any defense lawyer would want the judge to be a prosecutor. Now, sometimes judges are referred to as prosecutors in black robes. This is literally a prosecutor acting as a judge.
And many judges sit up there who were defense attorneys who ended up there. So it's
no, there were no defense. No. There are no defense attorneys doing that. That's the difference. There are no defense attorneys acting as a grand jury.
We will see a trial at which all of this stuff that he revealed will be laid out by the government, and the government will have to prove what he laid out and who he gave it to and why.
Judge will watch for you weeknights at 8 o'clock Eastern Time, 7 o'clock in Oxford on the Fox Business Network for Freedom Watch with the Judge.
For the fourth year in a row, freedom fading in America. Well, economic freedom, that is. That's according to a study by the Heritage Foundation.
The study ranks America 10th in the world for economic freedom, behind Hong Kong, Canada, even a small island nation of Mauritius. Fox News senior judicial analyst and host of Freedom Watch, Judge Andrew Napolitano, joins us. Judge,
good morning.
Economic freedom, what does that mean?
It means the government recognizing your right to own private property is superior to its right to take that property, and it means that the economy is generated by the free choices of consumers and investors. When we have something like Dodd-Frank, the economic regulatory legislation enacted by the Obama administration and the Democratic Congress last year, which authorizes the appointment of a bureaucrat with no standards, I'm talking about Richard Cordry, the Consumer Protection Agency, to regulate any economic activity he wants, including you deciding to pay the orthodontist over a year rather than all at once. The federal government has to approve that. That's a loss of freedom, the freedom to negotiate with the orthodontist. When we have an economic entity like this Consumer Protection Agency paid by the Federal Reserve, Congress can't even regulate what it does. We lose freedom.
You pointed to me when you talked about orthodontists correctly.
Because of your children.
No, because I had braces twice and every other known contraption that an orthodontist could give out. But let me bring you back to those other countries. I'm wondering, how do they come up with this list? What are the qualifications or the criteria to determine economic freedom?
Level of taxation and level of regulation. One of the reasons this presidential campaign is so important is it will be a great debate between those who believe that prosperity can come about by centrally planning the economy. It never does. And those who believe that prosperity can come about by the free choices of consumers and investors. There are countries in the world, and you just saw that list, where there is less regulation, more freedom of choice by consumers, lower taxes. The tax rate is flat. You don't pay more the more you earn.
In
Judge,
Canada?
Yeah, Canada. That's the exact one I was pointing to as well.
Canada is a bit of a surprise on there, at least to me, because we all know that Canada has a form of socialized medicine. The physicians are not employed by the government, but they are paid by the government, unless you are wealthy enough to go to a private facility, of which there are few.
And higher tax rates. And
yes, Canada is the oddball there. But there are certain Eastern European countries, even former Soviet states, where the tax rates are lower than ours, and it's actually easier to start a business and prosper because there's far less government regulation. This Dodd-Frank legislation puts so much power in the hands of unelected, unaccountable, and as we now know, unconfirmed by the Senate bureaucrats to monitor and regulate even the most minor economic activity. Wow. That's what saps freedom.
Very interesting discussion.
Thank you, Judge.
Thanks very much for bringing that to our attention.
Pleasure,
of course,
guys.
You can catch the judge on.
All right, major development now in the Supreme Court battle challenging the health care overhaul. That High Court will allow two business owners to join that case, a matter which is expected to decide whether or not parts of the law or the entire law is constitutional. Judge Andrew Napolitano, Fox News senior judicial analyst and host of Fox Business Network's Freedom Watch. Judge, good morning to you. You're all over this story, aren't you?
Well, you know, the Supreme Court has already decided what issues it's going to address, and it's already told the lawyers when to brief these issues, when the briefs will be due, and it's already set aside, as you may recall, Bill, a historic amount of oral argument. They're going to argue this
5 or 6 hours, right?
Correct.
Okay, so tell me the significance as to why these two business owners are allowed to join this case, or is it significant?
The Constitution requires that federal courts, from a trial judge up to the Supreme Court of the United States, can only hear cases where there's a real case or controversy. It can't hear hypothetical cases. So one of the plaintiffs in this lawsuit, and it's many lawsuits consolidated into one case, challenging the president's health care reform, has since gone out of business. So if the plaintiff, a small health care provider, is no longer in business, then it no longer has a adversity to the president's law and to the Justice Department. So in order to make sure that all plaintiffs have real adversary nature in here, a real case or controversy, the Supreme Court allowed another plaintiff to come in.
I got you. So let me be clear on this. The business that is no longer in business is part of this case.
Correct. And
because the business could argue that the law itself forced me out of business. My costs went up too high. I can't afford it anymore. Is that a fair argument?
Well, except that because this business no longer exists, it can't appear in the courtroom, and it can't have lawyers there to make an argument in its behalf. So to address this little gap, if you will, in the continuum between the filing of these complaints 2.5 years ago and the resolution of this matter by the Supreme Court this spring, the court has permitted another business to be substituted in the case at this late date, because this is going to be argued in 2 months, Bill, to take the place of the business that went out of business.
Is that a big deal? I mean, they want to hear all sides, right? They want to be fair and get a good evaluation of the evidence?
It is a big deal for legal scholars because it is precedent for future cases where someone drops out the last minute. The case can still stay there. As for the arguments that are going to be made in the spring, they're probably not going to change. And this person's lawyers are probably not going to make those arguments because there are too many lawyers in this case for the court to listen to all of them.
Okay, now I came across this article earlier today that talked about those who support the law thought they'd have a really good chance of upholding it when this decision comes out, and now they're not so sure. Now, are you hearing the same thing?
Well, yes and no. Bill, this is really reading the tea leaves, and people who do for a living what I do, which is watch the court and explain it on air, attempt to read the tea leaves. And every time one member of the court says something in a unrelated but similar case, we try to predict how they would rule on this case. Right. And so from reading those tea leaves, people have been changing their predictions. I've been predicting all along 5-4, Obamacare will be ruled unconstitutional on the individual mandate. And that will cause the rest of the bill to collapse. Most people agree with that, but some people have been changing their minds lately and saying 6-3, it'll be invalidated.
Who knows, right? Thank you, Judge.
Bill.
Good to see you.
Pleasure, my friend.
The GOP frontrunner Mitt Romney's money problems don't seem to be going anywhere. Today he acknowledged investing some of his many millions in the Cayman Islands. The Cayman Islands, notorious as a tax haven, of course. The Romney camp says he was not using the location to get any tax breaks. Though some experts disagree, say he probably saved a lot of money. Either way, it's not illegal to invest there, and either way, he won't release his tax returns. He says he will in April, but who knows? Those offshore holdings may be a political liability, though, don't you think? Fox News senior judicial analyst Judge Andrew Napolitano is here. He hosts Freedom Watch on the Fox Business Network. I have a number of bank accounts. None of them is in the Cayman Islands.
Well, your bank accounts are not suggested to be open for public scrutiny. You, at this point in your life and career, are not seeking the highest office in the land.
No.
Mitt Romney's problem is political. It is not legal. Those bank accounts are absolutely lawful. And there are many, many Supreme Court opinions which say you do not need to tailor your finances in order to give the most money to the Treasury. You have every right to use all the laws that the Congress has written and all the rules that the IRS has promulgated to minimize your tax exposure. However, the concept of the Cayman Islands, the idea of the Cayman Islands is it must be for rich people that are trying to avoid paying taxes. In fact, it is perfectly lawful and anybody can use it. So it's a political issue. It's not a legal issue with him. It may be an issue with respect to integrity because his people shouldn't have denied it.
What would be illegal is if you found some money that hadn't gone through the tax process and you just sort of stored it over there so the IRS, hoping that the IRS wouldn't find out about it. That would be illegal, but they're not suggesting he did that.
No, I don't know exactly what he does. I can suggest to you that he probably operates some limited liability corporations, and they probably have their bank accounts there. And they receive income there, and they pay their bills from there. When that is the case, when all the activity takes place in the Cayman Islands, you don't pay an American federal tax. And that's perfectly lawful. Now, if he takes that money from the Cayman Islands and uses it here, at that time he'll have to confront the tax consequences.
This isn't an unusual thing, is it?
It is not an unusual thing. They are making it more of a deal than it is because his opponents are trying to force him to reveal that he's uber rich to make him appear to be out of touch with the voters whose votes he's seeking.
Well, yeah, that's what they're trying to do, and he won't release his taxes, so that's that.
You know, this might all just fall by the wayside after Mrs. Gingrich's interview comes out.
You think?
I think.
Have you read some of that stuff?
I have read some of that stuff.
It's interesting that that was the man who was leading the charge to impeach the President of the United States.
That's the kicker right there, Shepard Smith. He can do what he wants with his private life, but when he's preaching the opposite. And leading the power of the government to dismantle the president is a serious, serious ethical and moral issue right there.
Of course, people would say, well, he broke the law when he lied under oth.
People in the government look at breaking the law differently than the rest of us.
Don't they?
See, your legal panel is roaring at that one, Shep.
This is what it's like in January. What's October going to be like?
Brutal.
Oh, my God. Catch the Judge weeknights, 8 o'clock Eastern, 7 o'clock in Oxford on the Fox Business Network. And if you don't get the Fox Business Network, you should...
Welcome back. After months of debate, President Obama finally rejecting that controversial XL Keystone pipeline. He and the State Department deemed it not in the interest of the American people, but Republicans on Capitol Hill say it should be built. It will create jobs, and they won't give up without a fight.
The president's policies are making the American economy worse rather than better. This is not the end of the fight. Republicans in Congress will continue to push this because it's good for our country and it's good for our economy and it's good for the American people, especially those who are looking for work.
So any chance that the Republicans can undo the president's decision? Let's talk to this guy right here, Fox News senior judicial analyst and Judge Andrew Napolitano, host of Freedom Watch, joins us live.
Steve, good morning.
Good morning to you. Okay, so the State Department, you know, we were waiting for approval. They gave it to this project a while back.
And once the State Department gave approval to the project, look at the pipeline. The blue is the proposed pipeline. From the top to the bottom are 56 different lawsuits intended to condemn property so that the pipeline can be built. Those lawsuits cost millions of dollars in the people suing, the Canadian utility, and the people whose property they're trying to take. All that comes to a halt. Once the State Department approved this, thousands of pieces of pipe and equipment was ordered.
Hundreds of miles of pipe.
Correct. Sitting in a warehouse. Who's going to pay for that? Not the federal government. Because when the federal government makes a mistake, when it changes its mind, when people rely on its decisions and then they lose money because of that reliance, the government has insulated itself from lawsuits. So the only consequence to the president here will be a political consequence.
Sure.
Does the American public really want this kind of on-again, off-again type of decision-making?
What can the Republicans do to see that this thing eventually is built?
Vote him out of office, because the statute gives the president absolute discretion to say yes or no. First he said yes,
but the State
then he
Department
said no.
already said yes before they said no.
Right. So the answer is political. I mean, could they change the statute? Yes, but it would take 2/3 of each House of Congress, and they don't have that much support. Interestingly, there are some Democrats that have criticized the president. Democrats running for re-election in states with high unemployment, where the pipeline would bring work and fuel, are as critical of the president as the Republicans have been.
I didn't realize how much exposure that utility had, and the pipe maker. I never thought about that.
$5 billion probably lost by that utility.
Oh, my goodness. All right, Judge Andrew Napolitano will be watching it tonight on Freedom Watch.
Pleasure. Thank you, Steve.
Thank you, sir.
The U.S. Supreme Court today issued its first ruling on the GPS tracking of suspected criminals. And every justice on the bench says police must get a search warrant before that officer uses technology to track the vehicles of suspects. The unanimous decision reverses the cocaine trafficking conviction of a Washington, D.C. nightclub owner. Back in 2005, police installed a GPS device on that suspect's Jeep, but didn't get a warrant first, and then used that device to help get him a life sentence for conspiracy to distribute the drug. Well, the Justice Department had argued that drivers do not expect their movements on public streets to be kept private. With us now, Fox News senior judicial analyst and host of Freedom Watch on the Fox Business Network, Judge Andrew Napolitano. The question was, I guess if they were to follow you and witness you on their own, that's one thing, but apparently this device is quite another.
Yes, actually there was a difference on the court on the issue of whether or not a warrant would be needed to follow you, even though that's not the facts in this case. In this case, they actually got a warrant from a judge in D.C. for 10 days. On the 28th day, they put the GPS on in Maryland. So the warrant had expired, and it was an area over which the warrant didn't even have jurisdiction. And the Supreme Court unanimously said, no warrant, no intrusion. Intrusion meaning putting the GPS inside the car. That's the actual intrusion that's prohibited by the Fourth Amendment. Following him on a public street would not be the intrusion.
Okay, so following him isn't an intrusion. What does this mean for the rest of us?
Oh, this is profound for the rest of us. It's profound that it's unanimous, and it's profound that the Supreme Court went out of its way to say that with modern technology, the Fourth Amendment still applies. In fact, in Justice Scalia's inimitable turn of a phrase, it applies today with the same meaning and intention that the framers intended for it to apply when they wrote it in 1789.
Huh. Does this change anything else about the way surveillance might take place?
There are probably hundreds of cases in the country awaiting the outcome of this one, where police use GPS devices without getting a warrant at all. These guys at least tried to get a warrant. They've violated the terms of it, as we discussed. All of those cases, depending upon the facts, but to the extent that the police did there what happened here, will go for the defendants. There may be other evidence of defendant's guilt, but any evidence obtained by the GPS device cannot be admitted at court.
I'm sure it's happened recently, but I personally don't recall any unanimous decisions by the Supreme Court recently.
This court every once in a while does come down with a unanimous decision. The decision last week about whether or not religious organizations were prohibited from using a religious test when they hire people to work for them was also unanimous. What's interesting is both of the Obama appointees rejected the argument in both those cases of the Obama Justice Department. I can tell you, put a black robe on, be told you have the job for life, your opinions change.
Yeah, or at least they become known.
Right.
Judge Napolitano, great to see you. Thank you.
Good to see you, Shep.
We'll watch for you weeknights on the Fox Business Network on the program Freedom Watch. Airs 8 o'clock Eastern.
The United States has conducted an operation that killed Osama bin Laden, the leader of al-Qaeda.
Well, I was happy when bin Laden was killed. Justice had been done. The killer had been killed. But I was not comfortable with that cheering. And my libertarian colleague, Andrew Napolitano, host of Freedom Watch, he knows more about the Constitution and rule of law than I do. He's an ex-judge. You called that murder.
I did call that murder. Not a popular thing to do, but the Constitution is pretty clear. The government can't take life, liberty, or property from any person. Doesn't say American, doesn't say good person, it says any person without due process of law. And we certainly can't kill someone just because it's popular to do so.
This guy admitted his role in murdering 3,000 Americans. It just makes sense that we ought to be able to go chase him down anywhere and kill him.
Well, it makes political sense, and that was a good move for the president. And emotional sense. Obviously, it was a great relief and release when this monster was dead. But he was not in the act of engaging in war at the time he was killed by U.S. troops. He ought to have been arrested and put on trial. Why would we make an exception for him and we would try Richard Speck, who admitted that he murdered 29 nurses in a Chicago dormitory?
Because your opponents say terrorism is different. And if we have a civilian trial, the terrorists will just abuse that to kill us. We'll put lives at risk.
There have been 2,300 people who have been tried and either pleaded guilty or convicted of acts of terrorism by the federal courts since 2000.
Civilian courts.
Civilian courts, not military courts. Military's only tried 7 people, 2 of whom it let go free. The president took an oath to uphold the Constitution. He can't make exceptions for emotional reasons or political reasons. He can't make exceptions at all. That's not me. That's the Supreme Court. When saying to Lincoln, you can't suspend the writ of habeas corpus even when they're shooting at your troops.
All right, here's one example your opponents give of why civilian trials are a bad idea. 1995, Omar Abdul Rahman, the blind sheik. He was prosecuted for conspiring to bomb the World Trade Center. The government's list of his co-conspirators reportedly leaked out of the courtroom, made its way to Osama bin Laden. This compromised our intelligence ability, our ability to stop the next terrorist act.
Well, I don't know if that is the case, but we do have an imperfect system, John, and it is not based on punishing the guilty. It's based on punishing those that the government can prove are guilty. If the government can't prove guilt, then the person is unworthy of punishment, no matter what the crowds think. That's also not me. That's the reason we fought a revolution, because the British king thought he could punish people he thought were guilty, no matter what the evidence was. They called it Star Chamber.
And speaking of the British king, you argue that this new Defense Authorization Act, signed New Year's, gives the president more power than King George.
It does.
Explain.
Well, for the first time since the end of the Reconstruction period in 1876, the federal government can use the military for ordinary law enforcement purposes. John, they're not going to be directing traffic. They're going to be arresting people that the president wants to arrest. So this statute purports to give, I say purports to give because I believe the courts will invalidate it, the president the authority to arrest whoever he wants for whatever reason he wants and ship them to Cuba, where they can't see a judge, they can't have a lawyer, they'll never see a jury, they'll never be charged with anything, and they'll stay there for as long as the president wants them. Historically, even the British king didn't have the authority to do that to the colonists.
Most Americans would say this is a democracy. That means rule of the majority. We elected Obama. We trust him to make the right decisions about that or to appoint people who do. And if we don't like it, then we'll vote for somebody else next time. But he and they want to keep us safe.
Well, the Constitution is to protect us from the tyranny of the majority, and it's to protect our natural rights. And among those natural rights is the right to be free from restraint, where the government can't prove the reason for the restraint. I mean, this president not only killed bin Laden, he killed at least 2 Americans using drones without any due process, without any standards, without any transparency. So his fidelity to the Constitution is meaningless.
Powerful arguments from a libertarian who is going against the grain. This Defense Authorization Act passed the Senate 87-13. Politicians aren't much interested in what's in the Constitution.
They are not interested in what's in the Constitution. I had an interview with Congressman Jim Clyburn, the #3 ranking Democrat. This is a year and a half ago in the House, asking him where in the Constitution the federal government can manage health care. And he said to me, Judge, most of what we do down here is not in the Constitution. That's the way politicians think. They'll wait for black-robed, unelected judges to defend the Constitution by invalidating unconstitutional legislation. Sometimes people lose their lives, liberty, and property before the courts can invalidate unconstitutional legislation.
Constitution's not very long. They could read it. Thank you, Andrew Napolitano.
Listen to this. Senator Rand Paul claims the TSA detained him at Nashville Airport after he refused a pat-down. He told Judge Andrew Napolitano, who's sitting right there, what happened next.
I got to the airport early, went through the screener like I always do, and it said, something's gone off on your knee. And I said, well, here's my pants leg. I rolled it up and pulled my socks down. I said, there's nothing there. And they said, well, we don't really care to look at your leg. And I said, well, you know, do you care whether something's there? There's nothing there. And they said, no, we need to do a pat down.
And that's when it hit the fan, so to speak. Fox News judicial analyst and host of Freedom Watch, Judge Napolitano here. Senator Rand Paul gets detained, correct?
Yes, he was detained for about 90 minutes, and he told us yesterday, during the course of which he tried to leave once, and they physically put him back. He tried to call his office to say, there are 200,000 people waiting for me to give a speech, a right-to-life speech, in front of the Supreme Court, and I'm not going to make the speech. And they said, we're going to take your phone from you if you use the phone again. Now, there's a number of issues here. One, they don't have the right to take the phone. Two, he has the right to choose which piece of equipment he wants to go through. He said, let me go through it again. There's nothing in my leg. Take a look at the leg. They said, no, we're going to pat you down.
That's weird.
Three, he didn't raise this. As a United States Senator, he cannot be arrested or detained for any reason on his way to Washington. Why? Because the Constitution says that.
That's right.
He didn't raise the issue because he didn't want to seek any special privilege for himself, even though constitutionally he's entitled to it.
Judge, here's what the TSA say. They say when an irregularity is found during the TSA screening process, it must be resolved prior to allowing a passenger to proceed to the secure area of the airport. Well, just run him through the thing again. He eventually missed that flight, went to another airline, bought a ticket, and went through the screener and was absolutely fine.
He told me that he thinks that there's just sort of a random alarm that goes off. that the TSA screener right there doesn't trigger the alarm. There's something in the mechanism that periodically triggers the alarm. If it's true,
to make it look like they're doing something?
Correct. If it's random, if it's not based on any genuine finding, that's a violation of federal law because it's stopping someone and conducting the pat-down search without a reason for doing so. Absolutely. It's also a violation of Cousin Janet's own Janet Napolitano, of HHS's own internal regulations.
So this is not the first time this has happened with him, though, right? I mean, he's got a little clash with the TSA before.
I don't know about the TSA problems before, but he told me that he flies from this airport all the time, and it's never happened at this airport.
Man, and I think I saw online that the White House said, we side with the TSA, and he was not detained.
Do we really have to surrender all of our freedoms just to get on an airplane?
Steve, answer him.
Speaking of freedoms, Freedom Watch is your program. What's on tonight?
Why are you ducking the questions?
What's on? Ron Paul's on tonight. His father's on with us tonight. Not to talk about
It's all
this,
in the family.
But to talk about what route he has, if any, to the nomination.
Apparently the judge's Rolodex was just stuck in the peas. The entire Paul family. All right, sir, thank you very much. Have a great
pleasure,
night.
guys.
According to an email obtained by Fox News from one of the Americans barred from leaving Egypt, the situation is very serious. The person who asked not to be identified says that the group is concerned about getting arrested and that, quote, "We believe this case will go to trial and that we will be prosecuted on a number of political charges." With that in mind, let's bring in the senior judicial analyst, Judge Andrew Napolitano. He anchors Freedom Watch on the Fox Business Network. How serious is this?
Well, I guess it is very serious. Remember, the military is very unpopular in Egypt at the moment, and striking at an American target, the son of a person in the president's cabinet, may very well enhance their popularity. I agree with Jonathan. I agree with the people Jonathan interviewed. The military does not want democracy. They want to stay in power as long as they can. And the democratic forces, question if they're really democratic, but the people that were behind the riots a year ago want the military to leave. So if the military can gather support around attacking an American, a relatively harmless American, but an American nevertheless, whose father is in President Obama's cabinet, that might gin up some support for the military.
Which is most likely the goal.
Yes, look, as we speak, there is no rule of law in Egypt. The military makes up the law as they go along. The military is prosecuting President Mubarak for people who were killed in Tahrir Square. Since President Mubarak left office, the military has killed more people in Tahrir Square than they've accused him of killing. So it is indeed a very dangerous place for anyone who would question its authority.
Here, listen to this. Oh, it's a full screen. It's a call for full screen. This is the email. Let's show you the email here. Several of us have been offered refuge at the U.S. ambassador's residence. This is the nuclear option. Doing this would raise this to a full-blown crisis if it isn't already.
Well, that's probably so. If you are to isolate Americans who are on the do not leave list in the one place in Egypt where the Egyptian military cannot go under all international standards, they cannot go inside the American military, you're raising the specter of what we once saw at the time in the Carter administration with the embassy in Tehran.
And that could be disastrous.
That affected the outcome of a presidential election.
Yeah, it affected a lot. Judge Napolitano, thank you. We'll watch for you on Freedom Watch, 8 o'clock Eastern Time, 7 o'clock in Oxford on the Fox Business Network. That's just up the dial, our sister network, FBN.
Then why'd you wait 6 months?
It took every second of that time for our technicals team and our engineers to figure out.
Let me ask you this. Between November 25th when you started and when you cleared it last Friday, the Secretary of Transportation says the Volt's fine.
The Chevrolet Volt was safe to drive.
Well, purposely delaying news of Volt fires to protect bailed-out GM, that is pretty much the charge against the Obama administration. Republicans are making today. GM CEO telling them that there was no foul play, nothing sinister, that his company feels like it's a political punching bag. To the judge who says usually where there's smoke, there's a battery fire. We did invite Mr. Ackerson on, the head of the GM. That invitation, always welcome, was declined today, but you know, hope springs eternal. The judge said yes. Happy to see that. What do you make of this?
Well, the government's in a very unusual position of being the owner of General Motors and being its regulator at the same time. And
So there's an inherent conflict.
Correct. This position was taken by President Obama. It was not taken by the Congress, but the Republicans are generally against it. The Democrats are in favor of it. Usually it's the Democrats that want to regulate aggressively. This time it's the Republicans that want to regulate aggressively because they want to demonstrate that the government shouldn't be owning and operating and regulating General Motors at the same time. The Democrats want to coddle General Motors because it's their baby. They like when the government owns businesses, and they love the unions that work for General Motors. So you have the parties working at cross purposes as they usually do, but each doing the opposite of what they usually do. To the questions we just saw, they're very profound questions by members of Congress. The answers basically were, we're not obligated under the laws that you wrote to tell you this stuff when we know it, because we have to demonstrate how serious it is before we make it public, and we have to tell the owners of these cars. But the laws were written before the government became a market participant in owning these manufacturers that it's regulating.
So let's say it is a big elephant in the room you're casting aside. GM was not owned by the United States government and had problems with a car where you had these fires or issues with some of the batteries. Wouldn't that argument hold that, look, until we can see there's a pattern and a trend, then and only then do we report? Is it more incumbent upon you to do that when the government owns you, or do you ignore that and focus on whether this is really a systemic
that is a superb question. The answer is
really?
It is.
Oh, thank you,
Professor Cavuto. The answer is there's no paradigm. There's no model for when the government owns you. The government has never owned anything as enormous as, and has never had as much stock in any company as it does in General Motors. But the Department of Transportation, which is the regulator here, has promulgated very, very precise rules for all manufacturers. And again, the rules came out before the feds bought General Motors about when this information is to be revealed. It doesn't want to disparage the product. It doesn't want to create a frenzy where one doesn't exist. But it needs to warn owners of these cars and those of us on the road who drive other cars that this battery could explode or these tires could explode. The regulators who were being grilled by Congress, good questions by Congress, are basically saying, we revealed it when we were supposed to reveal it. Congress is saying, we own you. You should have told us sooner.
No. You're kind of in a no-win situation.
It is a no-win situation, and it demonstrates why, under the Constitution, the government has no business owning a business.
Oh, here you go with that Constitution. All right, Judge, thank you very much. You can catch the Judge every weeknight on the Fox Business Network at 8 p.m. Eastern Time. You don't get FBN? Demand it! Because the judge will put you in jail for the rest of your life if you don't.
Ever thought that a Google search could ruin your life? One man says it has. A former NFL employee and now a high-profile prosecutor suing his two ex-lovers for bad-mouthing him online. He says the two women have created a negative website that pops up when his name is Googled, and that the website is ruining his reputation. So, does he have a case? Fox News senior judicial analyst and host of Freedom Watch, Judge Andrew Napolitano, joins me now. All right, so these women used to go out with this guy,
right?
And then
at different times,
yeah. And they, it ended, and it ended not so well.
Right.
And they went online and said stuff.
Right.
He doesn't like it. Does he have a case?
There's a couple of issues here. One is, are they revealing private facts about him in which the general public, has no legitimate interest? I think it's a little equivocal. They're basically saying he's a bum, he's a liar, he pretends he loves you and then he doesn't. Those are not serious allegations against him. They're not talking about private activity like financial activity or personal physical activity. This is their opinion. Are they permitted to state their opinion? Yes, they are. Can this be used as a basis for litigation? In my view, it cannot. It's freedom of speech. It's he said, she said. If they accused him of committing a crime or defrauding a client or lying to the court, that would be a basis for a case.
All right, so let's take a look at what one of these postings said. It was anonymous. Our relationship didn't last long, as I figured him out pretty quickly, but for others be forewarned, he's scum, run far away. All right, and then the statement from the guy who that was about. It's one of the pitfalls of the internet and our national obsession with Googling anyone and everyone we meet. They don't have the right to defame people on the internet. It's just wrong, and someone has to stand up. All right, now let me play devil's advocate for a minute.
Sure.
I kind of understand that guy's point. because anyone can go on and say anything about it.
Correct. Listen, I understand the fact that he is hurt, and I understand the fact that he is irritated that when you Google him, instead of getting former superstar athlete, former employee executive at the NFL, former prosecutor, high-profile lawyer, you get this nonsense about him. But the courts do not exist in order to right every wrong. Otherwise, the slightest little infraction or insult would result in litigation. So the court basically limits the litigation it's going to take. It presumes that all speech is free because of the First Amendment, meaning free from punishment. And because we have this presumption in America that speech should be free from punishment, we only punish speech that is profoundly untrue and profoundly harmful. This is a he said, she said.
Right, okay.
Should the women have posted it? No. Is it a basis for litigation? No. And this lawyer should know that.
And this will set precedent for this whole issue, won't it?
Well, if the court disagrees with me, if the judge who has this case, and if a federal judge has this in Lower Manhattan, says this case can go forward and a jury hears it, this will open the floodgates of litigation every time someone insults another person on the internet. The courts don't want that. They sit to address more serious issues that have a larger effect on people's livelihoods and wealth.
But in this era of technology, it's a fascinating case.
Yes, it is. How did you find this crazy case?
Been reading about it.
Kill me, come up with this one.
We've got such smart producers. They come up with all this stuff. All right, we'll be watching you on Freedom Watch on the Fox Business Network. There he is, pointing his finger.
Take it to our senior judicial analyst and host of Freedom Watch on the Fox Business Network, Judge Andrew Napolitano.
Sure.
You know, if we use a company computer to access our own, say, Gmail or whatever we do, the company, according to our handbook, has the right to that. They look at that if they want to. But the next part is of question.
Well, they don't have the right to reveal the information that they
that's what that's the next part.
And of course, the FDA is in a different position than our employers here at Fox, because the FDA is the government. And there's something called the Fourth Amendment, which regulates what the government can look at and what the government can acquire and what the government can do with private information. The Supreme Court has not ruled on this definitively, because you have the government as an employer, which is entitled to know reasonably what its employees are doing. You have the government as someone against whom a whistle has been blown by its employers. The government can't retaliate any more than any other employer could retaliate. And then you have the government as the government, which is subject to the Fourth Amendment. So all these competing forces here, these different hats that the FDA is wearing, have yet to be addressed in a case by the Supreme Court, and the cases are all over the place. Federal judges have ruled that the employer can look at, this is pretty well accepted, employee work-related emails. Some federal judges have ruled the employer can look at private emails. Some federal judges have ruled the employer cannot look at private emails. No judges have said the employer can look at private emails and reveal what they see. That's apparently what the FDA did here.
And the accusation is that not only did they reveal what was seen, but then they harassed them and even let some people fire.
I would think that these scientists and physicians have a very substantial case against the FDA, and I think it will be settled. The last thing in the world the government lawyers want is for all this to be laid out before a jury in Washington, D.C.
Yeah, I hear that. Judge, thank you very much.
You're welcome.
We'll watch for the judge on Freedom Watch over on the Fox Business Network. If you don't get the Fox Business Network, you should demand it.
Lawmakers trying to regulate themselves. Yesterday, the Senate voted to start debating a bill banning insider trading.
Judge Andrew Napolitano is a Fox News senior judicial analyst and the host of Freedom Watch on the Fox Business Network. And he's here to tell us whether or not this proposed law would make a difference.
Very little, actually, unfortunately. Look, the insider trading laws prohibit anybody from using non-public, privileged information that they obtained by virtue of their status and trading on it. It's perceived as cheating when they have secret information that something's going to happen with a company. Bill Gates visits a member of Congress, and that member and tells something to the member of Congress. The member of Congress goes out and buys Microsoft because of what he knows. The rest of us don't know it. The statute does not say that members of Congress are exempt from the statute. The Justice Department has decided not to prosecute members of Congress. So this new rule says, if it becomes law...
Oh, the Stock Act, right?
Correct. It's an acronym to prevent, for 4 words, to prevent the members of Congress from using special secret information. If you trade more than $1,000 in a stock, you have to announce it publicly.
Right.
You don't have to if your spouse does. You don't have to if your children do. You don't have to if you buy real estate because you know that the federal government is about to build a highway on that real estate.
You know, this ball got rolling. Peter Schweitzer wrote a book.
It's a great book.
A great book, and we've had him on this program. And then 60 Minutes excerpted parts of it, and we saw Nancy Pelosi's family benefited vastly from some insider deal, it looked like, and now they're trying to fix it.
Most of the insider deals involve real estate. Most of the insider deals involve members of Congress who are aware that the federal government is about to purchase real estate for its own use.
Former Speaker of the House, Denny Hastert.
Denny Hastert bought what appeared to be worthless, inexpensive real estate, sold it at a tremendous profit to the federal government so they could build highways there.
So this new law will do nothing to stop that?
Correct.
Wow.
It's a Band-Aid on a very, very serious wound that a Band-Aid is insufficient to help heal.
Thanks for the cheery news. All right, Judge, we'll be watching it later on today over on Fox Business.
Thank you, guys.
And it should pass right through the Senate, right?
It will.
Yeah.
There is growing outrage in some quarters of Houston right now over a case of alleged police brutality and some new concerns about your right to record what police are doing in public, even as the police install more cameras to track your every move. Several states are passing laws that would make recording the police illegal. They are citing wiretap laws as justification. But even where it is legal, officers will sometimes confiscate cell phone cameras or cell phones themselves just to get rid of any evidence. Judge Andrew Napolitano is our senior judicial analyst and joins us now. This is motivated by a case underway right now, being argued right now in Houston, in which a woman claims that she recorded police beating up her husband.
Right.
And she says that the police actually grabbed her cell phone, took out the digital card that records video to get rid of the evidence.
Well, that, of course, would be obstruction of justice by destroying evidence or something likely to be evidence. It would also be theft by the police. It would also be a violation of her civil rights, because under standard interpretation of the First Amendment, you have the right, if you're lawfully present, to witness the behavior of the government in public, and you have the right to record the behavior of the government in public. We're not talking about taking a camera into a courtroom or into a jury deliberation room. We're talking about police on a public street doing their job.
Right. So it astounds me to know that a number of states are actually considering laws or may have passed laws that say you're not allowed to do that.
Well, no states have passed laws, but you are quite correct that the states that you put up on the screen are contemplating laws that are motivated by pressure from the police unions, because the police do not like to be recorded as they go about their work, even though the right to do so is protected by the First Amendment. So those laws, in my view, would be invalidated by federal judges if they are enacted as soon as they become effective.
You don't think they're going to pass, or if they do pass, they'll get shot down?
I think they'll pass because the police unions are powerful in those states, but I think they will be shot down by federal judges who will articulate the traditional jurisprudence, which is you can take a picture of whatever you see in public. Think about it big picture now. No pun intended. Please take pictures of us everywhere we go in public, and they work for us. Why shouldn't we be able to take a picture of them?
Most police departments have dashboard cameras now, so they can record what an officer is doing, you know, pretty much every moment he or she is on duty. How is this different?
This is no different, except that sometimes the dashboard camera tapes disappear, like in Seattle, where 3 years of dashboard camera tapes have suddenly gone missing, and the police have no explanation as to their whereabouts.
Judge Andrew Napolitano, interesting. I know you'll stay on this.
Absolutely, John. Pleasure.
Thanks, Judge.
Thank you.
You can see more of Judge Napolitano on the Fox Business Network. He is the host of Freedom Watch.
In serious news today, the Attorney General Eric Holder appearing before the Congress to answer lots of questions over the failed sting Operation Fast and Furious. Of course, the program was supposed to track guns from the United States to Mexico. It didn't work out very well. Investigators say the feds lost track of hundreds of weapons and that 2 of them turned up at the scene of the murder of the U.S. Border Patrol agent named Brian Terry. The chairman of the House Oversight and Government Reform Committee, Republican Congressman Darrell Issa, has threatened to hold the Attorney General Eric Holder in contempt of Congress. Congressman Issa and other Republicans accuse the Justice Department of refusing to comply with subpoenas and engaging in a cover-up. That is a serious charge, and today the Attorney General rejected the accusations.
The magic word here, cover-up. And I want to make clear that there's no attempt at any kind of cover-up. We have shared huge amounts of information. We will continue to share huge amounts of information. There is a misperception, as I think was indicated in the Deputy Attorney General's letter, that maybe I can clear up now, that, we're not going to be hiding behind any kind of privileges or anything to not provide this committee with information that it wants.
Meanwhile, the family of the murdered U.S. Border Patrol agent is set to sue the Bureau of Alcohol, Tobacco, and Firearms for $25 million for his wrongful death. Let's get to our senior judicial analyst, Judge Andrew Napolitano. He's the host of Freedom Watch over on the Fox Business Network and does a lot of stuff around here. I want to start with what's going on with Attorney General Holder today. You holding him in contempt of Congress and making this is very serious.
Well, it is serious. The Congress can't do this alone, and Congressman Issa can't do it alone. But if the Attorney General and the people that work for him are refusing to comply with a lawfully issued subpoena, Congress can go to a federal district court judge in Washington, D.C. and ask that judge to hold the Attorney General in contempt of Congress. If that happens, that is a dramatic event which could result in his incarceration. It has never happened, but people who refuse to comply with subpoenas can be incarcerated until they decide to comply. Look, the best way for Attorney General Holder to address this is not to stonewall the Congress. If he thinks there are documents in there to which the Congress is not entitled, he knows that he can move before another federal judge and have that judge look at the documents and decide whether or not Congress is entitled to them. But irritating Congressman Issa in a case like this, where the Republicans have a majority, where there's an innocent person dead, arguably, as a result of all this, is not likely to result in a happy ending for the Attorney General.
Oh, I can't imagine that it would. Now to the other matter, and that is a $25 million lawsuit. Can that happen?
I don't think so.
Yeah, I didn't think
the federal government has clothed itself with immunity, which means that whenever it has to exercise discretion, whenever it has to make a judgment about how to run the government, and it would say that this Fast and Furious thing, as horrible as it is, looking at it in reverse, was a matter of judgment, the courts have said that those statutes prevent the federal government from being sued. There may be other intermediaries who could be sued, but not the Justice Department and not the federal government.
All right. A lot to go here.
Yes.
I mean, I watched in Megan's Hour, the last hour. Granted, they're still in the middle of an investigation, but that nobody's been fired seems like almost a tactical mistake.
There are tens of thousands of documents that haven't been coughed up yet, and they were demanded a long time ago. And if someone did that to Eric Holder, he'd send the FBI to go get those documents.
See?
Yes.
Judge, thank you. We'll watch for you tonight on the Fox Business Network. Who do you have on? You were telling me about a segment you have tonight.
We have...
In the elevator.
I forget what I was saying. The elevator, to be honest with you.
The brothel?
Oh, yes, we do. Yes,
Put him back on camera.
We have pimps and prostitutes for Ron Paul.
He needs to be on camera for this. Put him on camera, take the full screen down. Say it again.
Pimps and prostitutes for Ron Paul. This is a serious, major political event in Nevada. They're coming on Freedom Watch tonight to announce that they are in favor of the Libertarian candidate for president.
Pimps and prostitutes for Ron Paul. Donald Trump for Mitt Romney.
Yes.
We still don't know about Shakira and Big Bird, but we'll learn in the next hour.
Isn't it great being in this business?
It's the weirdest election season I've ever lived through. And I've been here for, it seems like, 130,000.
You look a lot younger.
All right, Judge. Freedom Watch, Business Network. Watch for that. You have to watch that. Otherwise, you'll be fined.